reasonable answer to it. And I would now open the panel for discussion. So in case if anyone has any questions, please let us know, or else we will give our closing remarks and end it. Yep. So Chirag, I want your thought process on the closing. What would, if you would have been a situation wherein you have to prefer the online versus offline, what would you have done?
As I mentioned, it's not online versus offline. It's not something which, this is not a choice in black and white. You will have to look at various factors. Who are the parties? Where are they located? Complexity of the dispute, number of parties involved, the nature of evidence which is involved, if extensive cross-examination is required, how many hearings are required, what is the value of dispute. And as I mentioned, as far as arbitration is concerned, hybrid is always the rule. Procedural order number 1, you would see most of the international arbitrator, they would do online hearing only. They would reserve physical hearing only for the purpose of cross-examination. And we have a phenomena of fast-track arbitration, which is also document-only arbitration, wherein no oral hearing is required. So, my dear colleague was talking about NBFC's disputes. NBFCs are resolving hundreds and thousands of their dispute on monthly basis through online fast-track arbitration. So it ultimately depends upon the user's choice. What do they want, and that's why the survey we are doing. Ultimately, it is for the GCs to make an informed choice, or the independent client to make. Ultimately, it should be an informed decision, rather than online is in fashion or physical is in fashion.
Thank you. And Susheel.
Yeah, as I mentioned earlier, it's going to be both online as well as offline. It's going always to be hybrid, and we will take a call considering the stakes involved, what are the reliefs we are seeking. Some important hearings we'll prefer going to the courts, but on procedural dates, we'll prefer offline to save cost and time.
Thank you, Chirag and Susheel. And Vivek, your closing remarks?
I might take a slightly different view from my learned colleagues. I think we are moving towards online, where yes, today the situation is for final hearings, physical hearings still preferred, but I think we are moving there because, be it big disputes, small disputes, the users want efficiency, the users want quick results, the users want disputes to be dealt with cheaply, even though at the end of some of these things there are multi-million-dollar legal fees bills, but they still want to do it quickly and cheaply. What they're not prepared to do is spend a lot of money or spend a lot of time trying to get diaries of arbitrators, counsel, and everything to match. They want quick results. And I think that is what's going to happen, both for big ticket disputes, but also for the small and medium disputes, which I think are a very big part of an economy, which sometimes we tend to ignore, because as lawyers, we want to go for the big ticket stuff.
Thank you. And Navdeep, over to you.
I think for arbitration to be widely accessible, it has to move online. Otherwise, it will always remain a niche form of alternate dispute resolution. And I think, we're 5 steps forward now, and I think it's going to go online all soon.
Thank you, all my panelists. I was thinking that this session is after post-lunch, but I'm happy that everyone heard us. And as I promised that I'll ensure that this session is concluded in 40 minutes. We are exactly bang on 40 minutes. So thank you everyone for your time, and thank you so much for your patient hearing. Thank you.
Thank you so much for such an insightful panel discussion. CRIT is the sponsor for our event today, and we would like to present a token of gratitude to all the speakers for gracing the event with their warm presence. So a huge round of applause for all of them. Thank you, sir. Thank you, sir.
Thank you.
Thank you, sir.
Thank you.
Moving ahead to the next panel, the topic of which is copyright. Moving ahead to the next panel, the topic of which is New Mediation Act 2023. The moderator for the panel is Mr. Sachin Kalra, Vice President and Deputy General Counsel, HT Media. The speakers for this panel are Dr. Manvendra Singh, Assistant Professor, Sharda University, Greater Noida; Mr. Victor Nayak, Assistant Professor, University of Engineering and Management, Kolkata; Mr. Rajiv Malik, General Counsel, LG Electronics Limited; and Mr. Rajiv Arora, General Counsel, Industar. We welcome you all, sir, on the dais. A huge round of applause for the next panel, please. Moderator. I would like to welcome the moderator for this panel, Mr. Sachin Kalra, Vice President and Deputy General Counsel, HT Media. Sir, you may now proceed.
Thank you, everyone. Thank you, learned panelist, Mr. Victor, Mr. Manvendra, Rajiv Malik ji, Rajiv Arora sir. Pleasure to be part of this panel and talking about this new act of mediation. Before getting into mediation, thank you all to be patient on Sunday evening hearing us today. When we talk about this topic, before getting into the topic, I'll just say, हर घर में एक लड़ाई होती है. जब घर में लड़ाई होती है तो कोई ना कोई तो बीच में मध्यस्थता करता ही करता है. तो that's a mediation basically. And that's a concept which is not from today. It's an ancient concept which has been built in the DNA of every person today or every family. Earlier days in Ramayana and Mahabharata, there was a concept of mediation. Ram went to Ravana to mediate and close the issue. Krishna was there between the Pandava and the other side, stating about how to mediate in between. It process starts ancient days, till date it goes on. But unfortunately, we have missed somewhere this entire concept, which I personally feel, which had been legally profiled or bona fide, came into the picture that yes, this picture has could have come much earlier in 1900 to us, and things of which has been dealt by litigation, long pending cases, disputes, going for many years, might have been resolved much earlier. So I'll not take much of time. I'll have good learned panelists with me and quite seniors from the industries here. When we talk about this Mediation Act, I'll ask Mr. Malik, Rajiv Malik, to give us some overview of how this act is, what was the ancient time, how it has been built in, and how the bill has come to the picture now. Mr. Malik, on you.
Thank you, Sachin, and good afternoon all. And myself, Rajiv Malik, I am a GC of LG Electronics handling the Noida manufacturing units, production subsidiaries basically. And this Mediation Act actually is 2023, but as Sachin has already mentioned, that this act, although this is a one step of ease of doing business as Mediation Act, but if we go in the ancient history, as we just discussed, that in Ramayana, Mahabharata, it was already there. And Shri Krishna has very well articulated the mediation between the Kauravas and Pandavas. And in fact, even after that era, and I would specifically talk about the pre-British era, at that time also village panchayat and elders were there who were mediating. And in fact, the disputes between the businessmen were being handled by the Mahajans, who had the strong hold of in business. So these things are there inbuilt already in our system. But yes, somewhere in the British era, we have lost it, and litigation was become the norm of the day. And we all see that the court procedures and Indian legal system is so complex nowadays that we all know, in fact, in the property matters, even the dispute starts, and then there is no means to end it, right? And the generations become the vulnerable in that case. And in case of child custody,